May it please the Court, my name is Richard Irvin. I represent the appellant claimant Marty Carmack in this workers' compensation appeal. I would like to reserve 5 minutes to respond.
I probably don't have to explain how the clock works to you, do I?
Thank you. The simple issue before this Court is whether the 2003 amended version of Section 440.13.2c has the effect of only requiring an employer carrier which unreasonably fails to act on a claimant's request for treatment by a physician in a medical specialty never before provided to pay for the past medical expenses of the physician who became authorized to care for claimant because of the delay, or whether the statute requires the continued authorization of the physician until it is determined that his or her treatment is no longer compensable or medically necessary. Now, the judge of compensations claims in the present case, relying on this Court's opinion in Butler v. Bay Center Chubb Insurance Company, ruled that although the physician requested psychiatrist Dr. Walker that his care was authorized by operation of law and that it was medically necessary, nevertheless he decided that the EC was obligated to pay only for his past, not continuing, or future care, and that the EC had the right to unilaterally deauthorize Dr. Walker and select another physician from its managed care list to provide claimant further psychiatric care. Now, it is the claimant's position that prior judicial interpretations that had been placed on Section 440.13.2c long before the Butler opinion remain viable, despite the legislative changes made by the statute in 2003, as alluded to by appellee in its brief.
What was the effect of the insertion by clearly the legislature inserted the word initial, 4 or 5 times in that?
It did? Well, I think it appears actually twice. It would appear to me that by reason of the fact that Section 440.13.2f created the one-time change of physician statute in 2001, and then the legislature made further changes to that statute in the year 2003, that it was necessary for the legislature then to clarify that Section 440.13.2c, which had formerly been interpreted to apply both to the initial request for treatment and to alternative care once a physician had been selected, that it was necessary for the legislature simply to clarify that the 440.13.2c now only applied by reason of the creation of subsection 2f, only applied to the initial request for treatment.
I notice you filed a supplemental authority, this Perotti case. How do you see that as figuring in?
The Perotti case states that where Section 440.13.2c applies, and this was a case that was decided on August 21 of this year, the JCC has the statutory authority to authorize a doctor for care provided during the period of wrongful denial. Now, in my judgment, wrongful denial simply means during the period of time that no determination has as yet been made that the requested treatment is no longer compensable or medically necessary. That would simply harmonize the provisions of Section 440.13.2c with those of subsection 2f that explicitly so state.
So you think that when the JCC acts on a claim like the one made here favorably to the claimant, the JCC authorizes the provider and the EC has to resort to sub D, get an IME and so forth.
Well, he could do that. That would be one way of doing it. That's probably the most frequent way of doing it.
If we accept your argument as to what the term initial means, then it leads to the question, I mean, claimant, let's say that the claimant makes a request for their one-time change. It's in a situation such as this, where she's no longer happy with her psychiatrist and now she wants to change that psychiatrist. Your position would be that she cannot change that psychiatrist?
If she makes the one, no, it's not. That's not my request.
The word initial doesn't mean anything under your interpretation.
It does under Section 440.13.2c. She would have to proceed under subsection 2F for a change in alternative care.
So she does. She says, I want to change, whatever doctor she wants to change. Now, you said that the word initial was to clarify that it doesn't apply in that circumstance.
No, because the provisions of 2F has superseded those of 2C insofar as requests for alternative care to that previously provided.
Is there anything in legislative history that tells us why they stuck in initial?
There is. I checked, Your Honor, the legislative staff analysis. I could find nothing in that. It would seem to me, though, that because the change that was made to subsection 2C was made part of the same act in the year 2003 when substantial changes were made to those of subsection 2F, including the language, I might add, which seems to be a codification of the judicial construction placed on section 440.13.2c, that insofar as it had previously applied to a request for alternative care. But the last sentence of section 440.13.2f now says, if the carrier fails to provide a change of physician as requested by the employee may select the physician, and such physician shall be considered authorized if the treatment being provided is compensable and medically necessary. Now, this language is simply a codification of the construction placed on the statute before the 2003 amendments.
Let me ask you this. What would you say to this argument that the employer had the right to choose the provider initially, and because of the dispute, which is presumably a good faith dispute,
the employer still has the right to initially select?
Well, not if the employee selection is treated as something the employer can do nothing about.
If the employer unreasonably delays, as occurred in this particular case, a request for initial psychiatric care, then, as the JCC said, pursuant to this court's opinion in Butler, then the employee has the right to select that particular physician and to care for him or her. But the extent of the authorization only applies to past care, that is, the expenses which the claimant had to expend for the care of the psychiatrist. That is pursuant to this court's opinion in Butler. Wouldn't
that be consistent with the legislative desire to hold down costs? In other words, recognizing that employer carriers enter into these managed care agreements, they enter into these other contracts with certain physicians, that they have more control over the cost of that care?
That's possible, Your Honor, but the legislature is presumed, when it enacts amendments to an existing statute, to be aware of prior constructions, judicial constructions, placed on a statute. And unless it makes its intent manifestly clear, it would appear to me that the legislature is simply, as in this particular case, because both amendments, that is the amendments to subsection 2F and 2C, occurred as part of the same legislative act in 2003. Therefore, you have to give an imperi construction to both of those amendments that occurred in 2003. And because there is really nothing in subsection 2C indicating an intent by the legislature to legislatively overrule past constructions which had uniformly been placed on this statute for years, more than 40 years, dating back to several Florida Supreme Court opinions. I suggest that the legislative changes do not reflect that intent.
Let me ask you something. Here's the JCC gave you part of what you wanted and gave the employer part of what
Yes.
they wanted. If we accept your argument, should we send it back to the JCC and tell them to make an all or nothing decision?
Well, the only effect would be to simply send it back to the JCC to simply with instructions that the portion of his order denying the claimant continuing psychiatric authorization of continuing psychiatric care of Dr. Walker be reversed.
Until that's what you're saying, but why would it not open up the whole thing? It appears that the judge was trying to kind of balance things out here. Wouldn't it give an opportunity to totally revisit it?
Well, he would have the opportunity to revisit it if indeed what appears to be the legislative intent, that is, that if it appears that the treatment provided by Dr. Walker is no longer medically necessary or that it is no longer compensable, then it certainly could be revisited, and it could probably be revisited by the EC requesting an IME for that particular purpose. That's the way it's frequently done. I don't see any insurmountable obstacle to the EC simply going back at an appropriate time and making that particular showing.
You are in your rebuttal time.
Thank you. I'll reserve the remainder of my time.
Hey, please, the court. My name is John Dubose from Orlando. I'm here representing the Department of Agriculture as the employer and the Division of Risk Management as the carrier.
Did you participate in the proceedings below?
I did, Your Honor.
Well, now, you didn't set up this issue as a defense, did you?
It wasn't set up specifically as a defense, although, as I pointed out in the brief, the issue was, and I'll just read it, past and future medical care and treatment as the nature of the injury and the process of recovery require, including psychiatric care and treatment as recommended and provided by Dr. Walker.
But wasn't your position, this man has a bad back, he doesn't need a psychiatrist?
And that no authorized treating physician had recommended or referred him or prescribed that kind of treatment for him. That was the main defense, yes.
So, to his credit, Judge Hofstad has been keeping up with the advance sheets. And, of course, Judge Hawks enjoys a particular reputation for his scholarship in this area. And so he takes, would you concede that's dicta in the Butler case?
Do I concede that it is?
Yes, sir.
Well, I spent a lot of time trying to argue that it wasn't. And if I could just speak to that issue very briefly, Judge. It's dicta in the sense that it doesn't deal with what appears to be the primary issue in the Butler case. But in that section of Butler, there was an issue about the employee, the claimant, saying, I think it was in March or April, that she needed a certain pain management. And the employer carrier saying, we didn't get that until she filed her petition for benefits in June. And so there was an actual issue before the JCC.
It wasn't the decision in Butler that, hey, the employer did authorize somebody.
That's right.
You don't get anything
Right.
else. But, I mean, wasn't that the idea? I mean, and then there was a twist that she didn't like that person, so she wanted to make a change before she ever showed up for a single appointment. But isn't that a very different case than what we have here? I mean, you did the first Butler comes up in the case is when you see it in the order.
That's true. Although
I'm sorry,
Judge, again, in the brief, I cited my argument during the hearing that this is a managed care case, and I said specifically to Judge Hofstede before he brought up Butler or before he made his ruling, I said it's our position that he's not authorized to receive the treatment at the expense of the employer carrier should the court find otherwise. We do believe that under the managed care system, he would be entitled to such care as the court determines is medically necessary, but within the constraints and confines of that system, the managed care system. That was my argument to Judge Hofstede before he made any ruling or before he mentioned Butler.
Okay, all right. I'm glad you brought that to my attention. Now, but you're not relying on anything within the specific statutory provision to do with managed care.
No.
You're relying entirely on 440.13 that we've been talking about.
That's right. But I was trying to make the point that we get to choose the doctor, and it's even more so in managed care because we do have the contracts directly with these doctors, and it does bring the cost way down for the state workers' comp system.
But the JCC decided that you violated the act by failing to provide psychiatric care when requested.
Right.
If you had provided such care, then you would have been restricted in any effort to change the provider to proceeding under sub D, right?
I'm not sure about that, Judge. Counsel made a lot of statements up here, and they followed through both of the briefs that the appellant filed as well about this statute. What is it, 440.13.2c, needing to follow that system. And I read every single case that they cited, including the two that they cited over and over again, Hill and Cal Covens. And neither of those cases deal with this subsection of the statute.
Counsel, if we say that the statement in Butler is dicta, therefore that only means it's not binding precedent. It doesn't mean it's necessarily incorrect. But counsel, appellant filed Perotti.
That's Perotti.
Yeah, whatever. And on page 8 of that opinion, it says that to narrow the extent, this section allows a JCC to order payment to a physician, comma. It also empowers the JCC to, quote unquote, authorize the doctors for the past care provided. So in this case, it's clearly relevant, and it says that it specifically says it the JCC permits the JCC to authorize the physician for past care provided. It doesn't say that the JCC can then authorize the physician for future care.
Right. That's exactly right, Judge. And that's where I was getting at with Judge Benton's question, is that in Perotti, this court uses the term that 440.13.2c is a narrow extent. It uses that term. It also uses the term operates in limited circumstances. And my point was, none of the cases that have been cited to this court for all of these, this procedure that's been used way in the past, applies to this subsection or its predecessor. It's usually used when a carrier is trying to deauthorize a previously authorized physician because they don't like him anymore, or there's an overutilization issue, which are other subsections. But none of the cases, and I even wrote them all down here and put out beside them, overutilization or deauthorization, that's all of those cases deal with. They never specifically dealt with the one we're here on today. And Perotti,
that's just a different motivation on the part of the employer. But it's just, the employer has the same problem. I don't want this provider. I want to authorize somebody else. I mean, you're drawing a distinction that I don't see why it makes any difference. I mean, doesn't the Act reflect the view that if you have in place relationships between the claimant and medical providers, they are not to be disturbed willy-nilly by the employer?
I think that's the overall, Judge. I think that is, based on all of the cases, that is the overall overriding concept, although, again, it's never been applied to this subsection. And the legislature specifically amended this subsection to insert that word initial, and I think it's inserted a number of times, more than 2 or 3 or 4, to bring home that point as it has been interpreted by this court in both Butler and in Perotti. Because Perotti says, to the narrow extent this section allows a JCC to order payment to a physician, it also empowers the JCC to authorize, that's what we're talking about. They want to authorize future care, but this court says it only allows the JCC to authorize the doctors for the past care provided.
All right, but once the doctor is authorized, he's authorized.
Yeah, but then we go back to Butler, you know. But,
no, I agree. The
Butler says that's
Butler,
it.
As I see it, dicta,
and Perotti does too.
Can't be squared. But now, but what about Hampton against Fantastic Sam's? You familiar with that case?
I don't have that one exactly. What's the first word? The first name?
Hampton, Hampton.
I don't have that one on my list here.
All right, so your point is that although if an employer complies with the Act, authorizes a provider, it cannot summarily substitute somebody else. Where it does not comply with the Act and the claimant is reduced to having to make his own arrangements, and the employer is finally taken to account and required to pick up the tab, that he can disrupt that arrangement with the provider and the claimant, between the provider and the claimant.
Of course, I'm in the position here, Judge, to affirm the JCC's ruling, and that's what Butler says. That's what Perotti says.
Is Perotti really saying that? Perotti's just talking about whether you can. It says that you can only get in the testimony of an EMA, IME, or authorized provider, and that where the employer wrongfully fails to furnish a medical provider, the provider that the claimant chooses is authorized. Isn't that what it says?
Well, actually, I mean, doesn't it say, accordingly, we hold that where Section 440.132C applies, the JCC has the statutory authority to authorize a doctor for care provided during the period of wrongful denial, and the doctor's medical opinion is admissible pursuant. So, I mean, it's talking about a limited period of wrongful denial. Once that period is passed, aren't we outside?
And that the court said we hold that. That is the holding of the court. And the period of wrongful denial in this case is from the time they denied it wrongfully to the time that there was a final order saying you have to pay Mr. Carmack his out-of-pocket expenses for everything he's paid Dr. Walker. But now we've told you you've got to provide him with a psychiatrist to treat these.
Let me ask something. It's kind of related, but just taking it from a little different perspective. If you had a client that had a good faith basis that the requested care was not medically necessary, is there any way that you could contest that and yet still preserve your right to choose the providers if we accept Appellant's argument?
I thought of that, Judge, and I don't see any way. I tried to come up with a way myself, and I just don't see a way that can be done. I think it all goes back in this case to what the legislature has done. There was an amendment to subsection F in 2001, and they didn't make the change then. So I don't think that the statutory construction argument that was made applies. But in 2003, they changed it this 4, 5, 6 times by adding this term initial in there, which I think means exactly what this court said it meant in both Butler and Perotti. So we would ask the court to affirm.
Thank you.
Thank you.
Very briefly, Your Honor, in response to the appellee's argument that prior constructions of the statute only related to the provision of alternative care, I cited in the reply brief Fuchs Baking Company v. Estate of Slosik, which is cited at page 11 of the reply brief, which stands for the position that claimant is entitled to seek unauthorized psychiatric care, just as in the present case, where the employer carrier failed to act on the initial request for such care and failed to offer any such treatment. I reiterate the same argument in regard that I previously made in regard to Perotti. The specific holding in Perotti was that the JCC had the statutory authority to authorize a doctor for care provided during the period of wrongful denial, and the doctor's medical opinion is admissible pursuant to Section 440.13.5e. I submit again that the period of wrongful denial simply means the time that no determination has been made by the JCC.
That's what they're saying, too. That's what they're saying, too.
Well, then perhaps they concede my point, then, Your Honor, if that's the case. In other words, if the JCC has not yet made a determination that the requested treatment is no longer compensable or medically necessary, then the wrongful denial simply continues. But as you pointed out, I believe that it's been some time since I read Perotti. I think it went off on different issues. And it clearly did not hold that only past medical care could be provided and quite frankly, Judge Hall.
They have cited another case where.
Sir?
They have cited no other case where the claimant wins on the issue of something having wrongfully been withheld, only to be told, however, you can't have that provider. I mean, there's no other case like that.
I haven't found any, Your Honor. I mean, I'm not sure I follow your argument. The only case that I think they rely upon is the Butler opinion, Your Honor. I don't see Perotti as being supported. If I may very briefly conclude, Your Honor, the doctor-patient relationship has long been recognized as a vital element in a patient's treatment. And because the legislature is presumed to be aware of prior judicial constructions given a statute, and there is nothing in subsection 2C since its amendment which reasonably implies that a physician's authorization created by operation of law should not continue until the doctor becomes deauthorized upon a determination that such care is no longer medically necessary. The order in this case denying Dr. Walker's continuing care should be reversed. Thank you.
I'd like to ask you the same question that I asked the state representative. It seems to me we talk about wrongful denials. There are wrongful denials where probably it was not a good faith denial, and there's somewhere, maybe there's a bad faith denial. So we kind of use that wrongful in a pejorative sense. But assume that a employer had a good faith basis to contest whether the treatment was medically necessary or not.
Yes.
Under your argument, how would they preserve the right to contest that and yet still reserve the right to be providing the doctor or physician that they think would be?
Presumably the care, because they don't have the right, I contend, under the statute as it is presently constructed, it seems to me that the employer carrier would be obligated to continue to provide that care by the physician selected by the claimant by operation of law, and then apply to the judge of compensation claims and make a showing to the judge that such care is no longer either compensable or medically necessary. That's what the statute says that's the last sentence of subsection 2F.
So you think they either have to decide to contest whether it's medically necessary and waive the right to
No, they don't waive anything.
Well, they are if they're doing what your client, if they accept your client's argument.
No case that I'm aware of has ever said that they waive by continuing to pay pursuant to statute.
Well, under your argument, they do. They can't contest it and still have the right to pick their provider.
No, sir, that's not what I'm arguing. I'm saying simply that they are under subsection, actually, let's say under subsection 2C before the 2003 amendments, the law was clear that the employer carrier simply could not unilaterally deauthorize a physician. It had to continue to authorize the physician and pay for his care. But if it presented facts or made a sufficient showing to the satisfaction of the judge of compensation claims that care was no longer medically necessary, then the judge could take that in consideration and grant the petition. Thank you.
Thank you. With that, we'll stand in recess until tomorrow morning.